Ray Snytsheuvel. Raymond, how are you?
I'm doing well, thank you very much. Thanks for having me on Bourbon with Bob again. And of course, I'm a Scotch guy, but I'm going to come on the show anyway.
I got a couple fingers of Angel's Envy going here. I'm East Coast time, so you'll have to wait a few hours out there,
Yeah,
Raymond.
it's a little bit easier for you. I mean, it's a little bit early afternoon for me. Not that it's beneath me, but I want to stay. I got things to do this afternoon, so got to pull my travel trailer. Got to make sure I can pull it straight. But then even then, trust me, I got my Scotch. I will be there literally in spirit with you. So
Good. Well, we're
good.
here today to talk about a new rule that's going to go into place 12/1/2025. Our goal here on Bourbon with Bob is to give information to BSA officers and compliance departments that are going to give you a little surer footing about the rules that are out there, especially new rules. And Ray and I will be the first ones to admit we don't know everything, but we know some good questions, and that might help further the conversation and get to answers. This new rule coming out applies to cash transactions where you have an entity or a trust that could be a sleeper, could be a phantom. The BSA is trying to, FinCEN through the BSA is trying to make sure that people don't get to transfer properties anonymously. And so they have come out with this new rule that says, let me slide through here a little bit, that you've got to, settlement agents, people preparing the closing disclosures, title, persons dispersing funds have got to tell us who owns shell companies, basically LLCs. Can't do it anonymously. And so for today, it affects cash transactions. But Raymond, when you and I were talking about this and trying to figure out what this thing meant, you raised a really good question right off the bat, which is, well, okay, we got to disclose if it's a cash transaction, but let's say you got 6 million purchase and you end up with a $20,000 first. Issues?
Yeah, I mean that's a good question. We got to look at these a little more deeper and see how this is going to be applied. Is it sneaky? I'm not trying to make up sneakiness, but we know clients are going to ask, right? So they're going to ask, like, well, if I have a $10,000, do I have to disclose it, et cetera? Well, these are good questions, to be honest with you. I mean, we can go back and discuss the whole premise and purpose academically as to why we need this, but operationalizing and reason for policy, so the academic side don't always mix well. But it's a good question. I mean, with some of the detail, how do we address some of this? But I think just the idea of disclosing, we've seen this MLBSA many other ways too. We'll talk about it, but disclosing information where historically we didn't have to do it, it's going to shake some people up. And by the way, it won't necessarily be people who are nefarious, but it is going to raise questions as to, I didn't want to disclose that, could be family issues, whatever. So there's a lot of this disclosure thing is going to be very interesting. And so we're going to be asked a lot of questions about what does this really mean? How do we live with it?
So you're a lawyer, and it raised some really interesting questions for lawyers in the commentary period when FinCEN's trying to figure out how everybody feels about this thing. Lawyers kind of lost their minds on that and said, you're asking me to do what? Comment on that attorney-client privilege and that whole issue. It seemed to be that FinCEN just wrote it off, didn't they?
Yeah, I mean, I've seen this before, and we know there's some kind of a threshold. Almost always is, even constitutional threshold, right? There's no pure constitutional rights. Everything is it depends. It's just a high threshold to get there. So the question here is, well, if I'm doing a closing, I'm an attorney doing a closing. Do I have to disclose now who my clients are? Because attorney-client privilege. And so there is an inherent conflict in rules insofar as what you'd have to follow. And what we're hearing is, FinCEN saying, well, we don't really care. You got to disclose anyway. And kind of more like dismissing that, attorney-client privilege isn't that important. It's scary, actually. We've lived off attorney-client privilege for good reasons. It makes for good law, frankly, and good jurisprudence and good justice. So with having to step into that and say, well, in this case, it's not a big deal. First of all, is that truly the case, and how do you approach that? And secondly, what's next? I mean, I have seen this before in other areas, other regulators saying the same thing. And, we have to deal with it case by case. But I will tell you, yeah, you're right. Regulators are getting a little bit bold about dismissing attorney-client privilege, and I'm seeing it here.
Okay, so you're in a BSA position, you're in a compliance department, and you see a transaction come through with $6 million of down payment and $20,000 of loan.
Mm.
That might rise to the level of a suspicious activity report. Whether or not somebody reports the identity of that employer, the source of funds, something. If there is a hint that somebody's trying to get around these reporting requirements, that might rise to the level of a SAR filing.
Yeah, I don't think I disagree with that. I mean, oddly enough, this requirement is creating that, right? So in and of itself, if someone has a $6 million property and a $10,000 or $20,000 first mortgage, in and of itself, does it look suspicious? Probably not. But now it might look a little bit suspicious, right? So maybe it is triggering SARs. At least you have to contemplate it and see how you're going to apply this. It's a matter of policy, if not at the loan level.
So, in case people think that this might not be a problem, I want to point out some things we know about New York. These tiny spires, if you haven't been in Manhattan much in the last 6, 8, 10 years, you might not know about these things, but they've sprung up all over Midtown. They're so tall, they look like a cartoon, actually. And there are YouTube channels devoted to these things and the luxury apartments that are in them. But so many of these things got bought anonymously. Let me give you some stats from a study done. Half of all purchases, $5 million or more, were done anonymously. 77% of luxury apartments in New York City are done anonymously. And right here over on the right of this shot, a little out of frame, is Columbus Circle. And the Time Warner building over there had hundreds of apartment complexes bought anonymously. And, it's no coincidence that a lot of this came from Russian money as soon as they privatized oil and a lot of things. A lot of that money found its way into New York. We had what are called these geographic targeting orders, where FinCEN wanted to have, I'd call it a dozen of the major areas, New York, Miami, New York, and Los Angeles, disclose this kind of information about who's purchasing real estate. This new rule seems to be just spreading that philosophy all across the country. If it's a big property and it's paid with cash, you got to disclose who owns it.
Well, I mean, that could be fair. I mean, I'd be curious to know, Bob, in those places, like who owns them, right? I mean, that raises a question. So,
Well, let me give you this guy, Roman Abramovich. Here's a map done by somebody who didn't mind putting their life at risk, and charted out where Russians had bought properties all over Manhattan. And this guy bought properties at 9, 11, and 13 East 75th Street. And to show you where those are, here's where the properties are that he purchased and paid cash. And he wanted to turn this, and this all into one big building. He has since ended up on our SDN list, and we can't do business anymore. But they've been tracking these guys and the properties. Now, part of the reason that this turns into such a big problem is that it really lends itself to money laundering. I mean, that's really the heart and soul of the problem here. You end up with somebody who puts cash. Maybe they stole it from a government. Maybe they stole it from people in distant lands. And that's what they're finding with the purchase of these things.
allegedly.
Allegedly.
That's our we want to stay alive.
Personally,
too.
I think Abramovich is a prince. He did nothing wrong. I like the guy a lot.
He won the lottery. So whatever happens,
I
but
like the guy a lot.
Yeah. Well, look, at the end of the day, I mean, it begs the question whether we need this again. I guess, because like I said, we can't even do business with him. And would we catch it otherwise if it were stuck on an LLC and didn't disclose? So, it runs into the face. I mean, regardless of what you believe of AML, BSA, and having to disclose this information, it runs in the face of it. And sometimes you nod your head and said, okay, yeah, that makes sense. You make a good case there as to that would have been good to disclose. I think, however, in the operations, there's a lot of challenges, right? I mean, there's a lot of challenges of what information you have to collect, who has to collect it. What do you do, Bob, if you don't really, how valid does the information have to be that you give me that I can say, yeah, that looks legit or not legit? These are the kind of questions that would come up operationally.
Well, I mean, that's a good question. And FinCEN did address the reliance upon identification that is handed to you. They addressed that and said, let me read it here. The reporting person may rely upon information provided by other persons, absent knowledge of facts that would reasonably call into question the reliability of the information provided. Pardon me, it's an emotional topic. I need a bit of
That's what happens. Maybe you got cheap bourbon. Be careful.
I shared a funny but true story in my newsletter this week of being 16 years old, looking like I was 12, and using an ID to buy some Miller Lite on a Friday night. And the lady said no, and the husband shouted from the back office, "If he's got ID, sell it to him." So I think that is knowledge of facts that would reasonably call into question the reliability of the information provided. I think the ID said I was 24.
Let me guess, you look 12.
Yeah, baby face. You can't just blink and say, hey, he handed me ID. It's got to be believable. It should create a little bit of worry among people who are saying that they attest to the information provided. But it does get back to this lawyer issue and the attorney-client issue. Let's talk just a bit. I hope I'm not catching you flat-footed about this Corporate Transparency Act ruling out of Texas this week. I think you're familiar with that. Texas said no go. You can't make people file these beneficial ownership information reports, the BOIR reports. And so that's on hold, right? We're not,
and Bob, I want to make clear those are two different things. What we're talking about, right? The real estate
totally
is different than the CTA, right? So,
yep.
So I want to make clear that that's different. And I mean, I don't know if the fundamentals are any different, that the real estate couldn't be also challenged. But again, I haven't lawyered that, so I can't tell you. But unless you can think about that. But yes, I think the CTA is different. And that's on hold, probably though for similar reasons that we might have some concerns, I suppose. What do you think, Bob?
But I think what's important for BSA officers is to kind of hear the distinction between the two. The BSA goes back to 1970, the Bank Secrecy Act. Okay, and that's the founding principle on which the FinCEN is acting. It was challenged when it first went into effect by the state of California. They said, hey, you can't make us disclose the owners of accounts at our banks. And they lost. 1974, the Supreme Court ruled that, yep, we can. And whatever the reason why, the Supreme Court said, if people are voluntarily going to institutions, they're voluntarily giving information and playing. They're playing in the game because they've given information to institutions. We can regulate institutions. This thing in Texas with the CTA, I think, is different because the Corporate Transparency Act sort of applies to everybody. I filed a BOI report on, okay, so we filed them, right? So, and it didn't take long. It took me 10 minutes, right? Done online, piece of cake.
Correct.
But I don't have any relationship with a bank that's requiring me to file that report. They just said, you got to file. And so I did. And I think that's going to be the distinction. What's useful for our BSA people and the compliance people is to know that those are on separate tracks. The BSA may get challenged at some point. It's been upheld for 50 years. It may get, but it seems to be unaffected by the ruling down in Texas.
That's interesting. And again, fundamentals might be different, but the relevance here, and I think where we might find some issues, at least in our space, my space being mortgage lending, and particularly the corporate world within mortgage lending, on filing beneficial ownership, is some of the either the mortgage lenders or maybe some subsidiaries thereof are maybe owned by people who like to stay like their anonymity, and maybe not for nefarious reasons, maybe for nefarious reasons. So I even think that the CTA is going to create some issues in mortgage and maintaining licenses, for example, and having to disclose that. I've seen that a few times in my industry. I've had situations where I've had in a state, I've had the governor's brother who was applying for an application, and I had to hand walk it to be careful and keep at arm's length and blah, blah, within the state where this person was a governor. So, people like to keep things a little bit either more diligent, or I don't want to say anonymous, but more thoughtful about their disclosure of who they are. So, and again, honestly, for nefarious reasons, but I think that's going to be an interesting thing if the CTA wasn't put on hold, and how you do that. So these are things that again, this is beyond necessarily a function for, well, I shouldn't say that. The AML BSA officer is probably going to be consulted on this and say, do we really have to do this? And this is going to affect our licensing, for example, because now in the LLC, that's the joint venture within this company, the 49% owner is such and such company, or, could be foreign national, whatever it is, right? Could be something else that they otherwise didn't feel comfortable disclosing. Usually, by the way, it's actually going to be less than 10%, but you get the idea. Things might have to be disclosed that weren't disclosed before. It's easy for you and me, Bob, because we disclosed, it was you and me in our companies. Maybe somebody else for you. For me, it's my wife, I suppose. But this whole CTA can get touchy as well, even though it's on hold. We don't know what's going to happen once it gets clear, its appeals, if it does, and where we go from there.
I'm thinking that the best advice for BSA officers and the compliance people trying to run a good shop, trying to be diligent about this stuff, is to just pay attention to issues when they might need to file a suspicious activity report. It doesn't mean they need to be experts on the corporate ownership of this guy or that, an employer. But if things look like they're being obfuscated, I think that rises to the level of a suspicion. I think that can get reported. I would be suspicious of a $6 million purchase and a $20,000 first.
You would now.
I think I'm just going to report that one. So let's see here. So they're coming. And they want these things. This is a rule that's going to go into effect December 1, 2025. They've dismissed the idea of attorney-client privilege. They're saying we need these filed by anybody involved in cash transfers of real estate. Let me just say a final thing about the money laundering aspects of this. If I can get a property that I purchase anonymously for $1 million, and I want to launder 5 million. If these are just anonymous transactions, I can sell that anonymously to another entity. And most people listening to this are going to go, that's not my world. That's not the world I play in. But Abramovich plays in that world, and other people play in that world, and they end up on what we call our SDN list, or the specially designated nationals list. Last list of specially designated nationals, people and companies you can't deal with, runs 2,200 pages. And it is a who's who of corporate criminals and others in all kinds of countries you can mention, from South America to Ukraine and Russia and everywhere in between. 2,200 pages of names. They are doing this. They are transferring property. They are making them $10 million in gun running and then using that money to buy residential real estate. And I think that's where this comes from. Some of us look at it and say, man, another regulation to live up to, another burden on us as an industry. And we just forget how many really bad guys are out there trying to shuffle their money around through real estate. I mean, we shuffle so much money around in this mortgage industry that it's easy to forget that they're bad guys that also want to hide their money. Final thoughts, Raymond?
I respect that. I mean, I think, well, the concern I always have is in any type of regulation is what risk are we trying to hedge? The rules that we put in place, is it narrow enough to get what you were looking for, but not so broad that it's going to create questions and ambiguities and complications in operations applications in real life. And so you're right. Maybe we don't run in the world of a $6 million property cash with a $10,000 first mortgage, but there are tens of thousands of transactions that are otherwise legit and pedestrian that we now have to wonder, did we do this correctly? Whatever. Right? It's always an issue. And so, maybe this one they keep it tight enough from the real estate side, the CTA, which really is that's the reporting at the corporate side, but it's starting to eke into operationally, what do we do here? And I'm always protective of the mortgage operation to make sure that we don't put things in place that complicate things and don't hedge the risk it's supposed to.
We all take our shoes off to go through airport security because some doofus tried to go through security and was it Minneapolis with a shoe bomb, Richard somebody.
Yep.
So we all, for 15 years now, we all take our shoes off to go through security. Security in Europe doesn't do that. They wave you on through.
Correct.
But one guy does a dumb thing and we all take our shoes
away.
off for 15 years afterwards. I understand the balance. We're trying to not have bad things happen. And that gill net sometimes sweeps us all up when you're looking for criminals, and we're in no way criminals. We're just trying to do our job. It always makes me reflect, though, if your job is to prevent financial crime, if you are working at FinCEN or Treasury and you're trying to stop this stuff, how dumb you look if something huge happens right under your nose and you haven't put something in place to stop it. So I'm empathetic to those guys, but it's the shoe bomber kind of balancing you're trying to play with here and make sure that most of life can go on.
I can respect that. I mean, we see that maybe with crypto and other things too, right? It was tough to regulate. There were issues. I think it's coming back. I don't know. That's not my specialty. But I will tell you, Bob, you're going to get a lot of comments because everyone's going to say, "Don't you have TSA pre-check, Bob?" So you don't have to take your shoes off. So you get a lot of comments on that. But if not, I'll tell you what. I'll wire you $85 so you can get yourself a TSA pre-check. All right, but where you want to go with this, Bob?
Hope this has been of help to our BSA people and our compliance people, and we'll look for you the next time we raise a glass.
All right. Yes, I certainly would. I'm sure I'll bring down my scotch next time. I promise.
All right, Raymond. Thanks so much, as always.
Thank you. Thank you very much.
You bet.